absolutely appreciate the time limits Your Honour has imposed. I do want to assist you with answering questions. It only helps my client, and it can only help Your Honour. If I feel I want to ask for an extension at the end of my submissions, I may do so. But we'll cross that bridge when we get to it.
Yes, and it won't be a bridge you need worry about until about 1:45 p.m.
Thank you very much, Your Honour. So can I explain this? Can I come back to section 5 of the biosecurity determination?
Yes.
There's a lot of sections, isn't there?
Can Your Honour look at subsection 2?
Djokovic's not getting sectioned, is he?
Recalling that the extract given in the notice under 119 was of subsection 3, which intersects with subsection 2. Right? Now look at subsection 2. It says the individual must be able to produce to a relevant official evidence that before the individual boarded the aircraft. Right? So this is in.
If anyone in the live chat wants to send us like a summary in English, then feel free to. I'll keep playing.
Oh, no, just pause it a second, man. Pause it a second. I just want to make sure are you both following this exactly? Because listen, a lot of this has been double Dutch. I'm trying to keep with some of the key points. The words and terminology they're using doesn't make total sense. But John, I know you've got something to say, so over to you.
Yeah, just a couple of things. I think just for, again, at the beginning, it may have taken a little while. We've got the three judges, or we can only see two of them on the screen at the moment. One of them has a formidable beard, by the way. They are obviously on the behalf of Mr. Djokovic, and the people obviously for the government are the people on the right of the screen right now, with obviously the judge in the bottom left. I think at least we're getting a bit from a tone that the judge initially didn't seem too amused with certain things that the Djokovic lawyers were saying. However, I do think he's softened a bit in the last few minutes, and that he's a bit more like, okay, but it's like you. I'm still trying to. I mean, I'm not a legal expert or understand, but you can get a feel for things, especially, and obviously, again, I didn't know until right now, but this is all being done online, shall we say? Although obviously there is a courtroom exactly where the judge is, at least, but the other dudes are obviously in various parts of Melbourne, presumably.
Yeah, right. We're going to get back to it. Just one thing I want to say: this is the first court hearing I've ever watched live of any regard ever. Probably the last. I'm not enjoying it much. Hit play, Ben.
I was going to say it's not much
it's
like
the first and last. It's not that. Listen, I much prefer the tennis.
Ben, when you do press play, you'll have to go back to the where the video is right now, if you know what I mean.
Yeah, that's fine. I was going to say it's not much like the O.J. Simpson case. This one, is it?
No.
No. Let's go live, John.
Before
you don't want to miss anything.
Mr. Djokovic boarded that aircraft, he made a written statement that included.
Yeah.
Right. But Mr. Djokovic, and I'll come to this in due course.
Sure.
Did indeed provide that material, that evidence from medical practitioners before he boarded the aircraft. Now, to park that for a moment, I just want to be as clear as I can about the point we're trying to make here on it. Now, if we can go back to the biosecurity determination, we've talked about sub 2 and sub 3.
A lot of biosecurity.
Can I take you on it to sub 7?
Yes.
Okay. A distinct requirement. It says, if a relevant official asks the individual to do so, the individual must produce, and then go here relevantly to B. If the declaration included the individual statement was of the kind mentioned in 3B, which is the case here, the evidence mentioned in paragraph 3B2. So it's a very clear and distinct process. You make the declaration before you board the aircraft. You say, I declare my status, unvaccinated, or rather, sorry, medical contraindication, and you declare that you can produce the evidence. Later, only if you're asked, under sub 7, do you have to provide it, the evidence. Now, the point that matters here, Your Honour, is come back to attachment A, recall the function of the section 119 notice, of which attachment A was part. Your Honour will recall that under the Act, and the cases are crystal clear about this, the decision maker, in advance of making the decision, must provide particulars of the grounds. The only relevant particular that was provided here, so far as it relates to the biosecurity determination, was 5 sub 3, not sub 7. So Mr. Djokovic was never even notified, as he would patiently be required, if indeed later the decision maker was to decide that there was a ground flowing from something else. But he was never notified under the 119 notice that he had breached sub 7 by failing to, quote, produce evidence relating to his declaration on request. He was only ever notified of a particular of the proposed ground of cancellation, implicitly that he had not complied with section 5 sub 3. But that obligation was only to make a declaration, not to provide evidence.
I understand it.
Thank you. So, Your Honour, would probably appreciate, therefore, why this, yet again, not to undercut its significance, but legally is a very simple point. Let's come back to part B of the decision record, which sets out the reasons, or more precisely, details of the evidence and findings. We were looking at paragraph 2, and I make the point that the middle sentence, in context, has to be read in light of the section 119 notice that cited only section 5 sub 3 and not section 5 sub 7, can only be understood in context as suggesting that the declaration that is required to be given under sub 3 must be accompanied by evidence of the medical contraindication, manifestly incorrect at law. Now, beyond that, Your Honour, skip over the next, the remainder of that paragraph, and skip over the next one for a moment and come to the fourth paragraph that says, all visa holders, whether permanent or temporary, are expected to abide by all public health directives issued by both Commonwealth and state and territory jurisdictions. A breach of these directions is considered a potential risk to the health.
No, everybody.
A breach. Should I proceed, Your Honour?
No, you should not. The court will adjourn briefly.
What happened there?
The Federal Circuit and Family Court of Australia stands temporarily adjourned.
There we go. It's a nice little juncture for us. I just heard I don't know what the judge was when he said you may not. I don't know what that bit
guys,
was.
we're just waiting for the court to start again.
Do you want to put them on a mute, Ben?
It's just waiting for the
pause, and you can see
the judge has asked for a temporary pause.
We can hear it, Ben.
Both sides.
Yeah, we can hear it.
Oh, okay, I didn't know if you could still hear it.
That's where it's at.
1 second.
This is live. It's happening right now in Melbourne, Australia. Federal Court of Australia. This is to do with Djokovic and his appeal against the removal of his visa by the Australian government. And if I may add my own comment, I think it's absolutely disgusting the manner in which Djokovic has been treated. Here we go. We're back again.
Open the court.
Silence.
Right.
The Federal Circuit and Family Court of Australia is now in session, recalling the matter of NOVAK Djokovic v Minister Home Affairs for hearing.
Please continue, Mr. Wood.
Thank you, Your Honour. We were looking at paragraph 4 of point 7, and I read it out to Your Honour. That the substance of it is, it says, all visa holders expected to comply with public health directives issued by various jurisdictions. A breach is considered a potential risk to the health, safety, or good order of the Australian community. That paragraph can only sensibly have been included in this part of the document, which invites, quote, details of the evidence and findings about why the delegate is satisfied the grounds exist, particularly in light of the statement in the final paragraph, based on the above information I am satisfied. It can only sensibly be understood as forming part of the delegate's reasons for why Mr. Djokovic was considered to be a potential risk of the health, safety, or good order of the Australian community. The only legislative provision that might be capable of being characterised as a public health directive issued by any of the relevant governments is that which was identified in the section 119 notice, and that is section 5 sub 3. It is manifestly not the case that Mr. Djokovic breached section 5 sub 3 of the biosecurity determination, and any conclusion to the contrary is clearly erroneous. What Mr. Tran and Ms. Woodman submit, Your Honour, is that one is to, in effect, generously read point 7 and assume that what the delegate is speaking of is section 5 sub 7. That submission cannot be accepted for two obvious reasons. Number one, as I've been at some pains to try to explain, section 5 sub 7 was not particularised as a basis upon which the ground for cancellation existed in the Section 119 notice. So if it is now sought to be reconstructed as, in effect, what the delegate meant, then one would have the clearest jurisdictional error imaginable, which would be a finding that a ground exists based on a matter that hadn't been the subject of the Section 119 notice, which required particulars of the basis upon which the delegate appeared to think the ground existed, just QED. In any event, Your Honour, it would be erroneous because Mr Djokovic did provide evidence both before boarding and after arriving at Tullamarine of the matter. Now, can I take Your Honour to an important piece of evidence? Can I take Your Honour to Bannister Affidavit number 4?
Yes.
Bear with me. Bannister Affidavit number 4, in the body of it, records, and I won't bore Your Honour by going through all of the email chains, but in substance records the fact that Ms Bannister continually asked AGS, I'm not being critical of AGS, but we kept making requests as soon as this situation emerged on the early hours of Thursday morning for the material before the decision maker and what was on the records of the department. What ultimately came back relevantly to this point is the document at page 35 of the affidavit.
Yes.
It has the heading ATD for Novak Djokovic.
Oh, here's TK. We're in.
Can I ask whoever is on screen to make sure they mute themselves? There is every important that the only people who should be online with their microphones are those who are making submissions to the court. Any other behaviour by any person who may be wishing to watch this live will produce a very real risk that the bandwidth available for this hearing will be overwhelmed and the hearing will be interrupted, and that is utterly unacceptable. Please continue.
Thank you, Your Honour. So if Your Honour is at page 35, you'll see that document is headed ATD.
It's a bit of a hard ass, this judge.
Australian Travel Declaration for Novak Djokovic. This is the document that was completed by Mr Djokovic or his agent before his arrival in Australia. It was the form prepared by the government to facilitate compliance with Section 5 sub 3 of the biosecurity determination. If we turn the page to page 36, you'll see question 9. It says, please provide your vaccination status, and therefore a series of boxes are provided, yes or no, that enable a traveller to comply with the requirement in Section 5.3 by making the requisite declaration. And Your Honour will see 9.1.1, again, part of the form, says, I declare I cannot be vaccinated for medical reasons. I'll come back to this document in relation to a later ground, but for present purposes, Your Honour will see that the box yes is ticked. The declaration, therefore, is made. Moreover, 9.1.1.1 says upload proof that you are unable to be vaccinated for medical reasons. And indeed, as I'll seek to demonstrate to Your Honour later, that proof was indeed uploaded. What was uploaded was the medical exemption document that had come from the Chief Medical Officer of Tennis Australia that recorded.
Can I ask you to pause here, because it's a matter that has really preoccupied me. The status attaching to this medical exemption, the applicant in this case, as with the vast majority of persons who may be said would with a permit rather than a vaccination can be assumed not to be a specialist medical practitioner. They all struck the contemplated arrangement that one would go where to a medical practitioner to obtain third person could issue the medical exemption for themselves. And extension, the evidence in this case, particularly significant, particularly visa once a person arrived. That here a eminently qualified physicians have produced to the applicant. Further to that medical exemption and this one which was separate by a independent and that document was in the hands of the and about more
Agree. And I made the global about what the interview. I won't go into detail for a moment, but I will in due course. It's utmost on the transcript of the interview. Djokovic at the airport, with his own driving when the tape was off.